You guys are tuned in to Break the Cypher. This is episode 2 with your boys. And we are continuing to follow the case in Telluride with Alpine Wellness and the town of Telluride. We're going to jump into kind of like a little bit of a recap of episode 1. If you haven't checked that out yet, hop on, and we hope you enjoy it. This next episode is, what happens when a government gives you 2 options and both of them are illegal, unethical, or unconstitutional. You know what I mean? And so we're going to bring it in with a clip right now. So you guys sit back and listen for a second, and we'll be sitting right here waiting when you get back. I do have a question. Can you please verify what part of the Telluride Code would require me to disclose federal tax default? And also, can you find a place in the Telluride Code where it defines default in the marijuana code?
The authority shall have the power to require any applicant or licensee to furnish any relevant information required by the authority. 6104.
66104.
Sub 3. There's also a requirement to pay taxes or you're out of compliance.
So in that 66104, there's no requirement in this section or anywhere in Title VI mandating disclosure of federal tax default. The town is enforcing a condition that exists nowhere in the law. This supports the constitutional argument I'm trying to make.
We're not addressing the constitutional argument. This is not, constitutional arguments are filed with federal court or the state court.
There's no requirement in this section mandating disclosure of federal tax default.
Wow.
Interesting.
Yeah. Huh.
Very interesting. I like how it's like, this is what the Telluride Code says. It's like the town of Telluride can ask for any relevant information. It's kind of weird because it leaves it up to them to decide or decipher what falls into the word relevant.
Yep. Yeah.
That's kind of, it's like, so you can just decide what is relevant, what is irrelevant. And the spectrum is based on the word any.
Yeah. Yeah. It's a blanket terminology.
And so to me, it still says, well, you're choosing to make this an issue. You're not required to make this an issue. This isn't a part of the code. You're choosing to interpret the code this way and to apply the language in a certain way based on any relevant. It's like, it's pretty like leaves it wide open. So anyways, last episode, we laid out the trap. A checkbox tucked into a license renewal form asking a question that isn't in the code. It isn't in the law in Colorado, and it carries federal criminal weight. But this time we're going to go a little bit deeper because it's one thing to recognize a legal contradiction, and it's another thing to live through the punishment for pointing it out. Kind of a big deal. And Alpine Wellness tried to play by the rules. They did not ignore them. They didn't ignore the form. They submitted letters. They cited the Fifth Amendment. They quoted Leary versus the United States. But when they refused to falsely incriminate themselves, they weren't met with fairness. They were met with silence. The government decided, we're not going to respond to you. You have all these requests. You have all of these motions and clarifications you're asking for. And they basically just looked the other way and went silent. And so the town of Telluride didn't argue the law. They didn't acknowledge the motions. They skipped the conversation and went straight to the confrontation.
Jeez. Yeah. Honestly, it's honestly being real. It wasn't confusion. It seems like it was by design. The town knew the question wasn't legal, and right down the road, another municipality removed it instantly upon seeing the contradiction that it held. So Alpine Wellness was not dodging the question or the form. They submitted responses, motions, and even cited the Supreme Court precedent. And yet, all of those, every single filing was ignored. And then the town comes back with, you can just change your answer on the form, No, like that's not resolution. That's cohesion.
Yeah, it is coercion.
Coercion.
Yeah. And you know, it's like, it's a hard word to say.
I know what I'm
Coercion.
thinking.
We should like Google it and be like, how do you pronounce coercion? Coercion.
Yes.
It's hard to say.
But
I know how to
there's-
say it.
But they're right. The fact of the matter is, like, it's leading you or leading Alpine Wellness or the applicant into a trap.
Yeah. You can just comply with us. You can just change your answer. And you know, it is like, that is kind of like a false choice. And I feel like when it comes to like, are you complying with the federal government? You know, if that was a question on the application, which in a lot of ways this is, you know, this is a federal tax policy compliance question, you know, but like, are you complying with the federal government? If we were complying with the federal government, if they were complying with the federal government, they wouldn't be selling weed. The federal government says you can't do that, and they keep saying that. You know, like, I've been watching a couple different cases going on, some news articles, and there is no sign that the federal government is saying, like, yeah, states can go ahead and do whatever they want. And so to comply with the federal government in this regard would be to not sell marijuana.
Right.
And so, I don't know. Let's go back to this checkbox. It's asking, are you in default on your federal taxes? Here's the trap. If you say yes, you're admitting to a federal crime under 280E. And while you're not getting charged with a federal crime, the punishment on a financial level is being applied and weaponized by the IRS. So none of these businesses have been charged with a crime, but they're the beneficiaries of the tax that would be applied had they been charged. And the IRS's stance on that is based on these businesses complying, because in the state and in the town, you have to report that you're selling marijuana, disclose that you're selling marijuana. There's seed to sale tracking, and it's very on the books. And so just that alone, like, when it comes to these businesses being exploited, it starts with like how we're, you know, having to report. And the IRS is like, well, we can see that you're selling weed based on how you're reporting. So, you know, you're incriminating yourself just by complying with the reporting standards and regulations of the industry. If you say no to the answer, and the IRS sees it differently, you've just falsified a public form. You know, it's like, so if you say yes, you're admitting to the crime, you're accepting the liability. If you say no, the IRS might see that differently, and you've just falsified a public form. And that being a public form, you know, I feel like that's a big part of it. Like, your answer, yes or no, is part of the public record. And like I just said, if you say yes, you're accepting that default, which Alpine Wellness will not do. They will not accept the default that is based on them being criminal drug traffickers. So the real choice is, do you lie and keep your license, or do you tell the truth and risk criminal exposure?
Jeez. Honestly, that is the definition of a false dilemma. You have two options, but neither are safe, neither are legal, and you have to walk that line. So let's remember, like, this question specifically isn't in the Telluride Code, and it's not required by the MED, the Marijuana Enforcement Division. And so where did this come from? And who benefits from putting businesses in this kind of situation where it's a no-win? And though it seems like this point can be made over and over again, like, as far as the language does not exist in the Telluride Municipal Code, here's what the town thinks about the language and whether or not it's in the code. Roll that clip.
As it stands now, the law in the town as the code requires you not to be in default. That was not challenged. That was not appealed, the conditions that were set forth. So that is where the town is at this point in time.
And I actually have one more to put in here too before we move on, but let's listen to this clip. They contacted the MED, and the MED said that's fine. It's not in our statutes either. And so I'm getting a little testy about the fact that you guys are forcing me to disclose information and fill out applications in a way that's unlawful.
It's not unlawful. We have the ability to make different rules, and we're doing so.
It was the same app. They adopted your application.
And then they modified it, which they have the authority to do.
Well, I feel like
Well,
you guys do have that.
And so now you're subject to it.
And so
Yeah.
now I'm subject to it, but I don't know that it's lawful.
Well, you're welcome to challenge that in an appropriate venue, which is a court of law, not here.
Okay. Yeah. Seems like that's like a common response from the town. This hearing isn't the place to address your rights as a business owner in town. And what I'm also hearing is like we get to make our own rules. We get to make the rules.
Yeah.
Those rules don't apply to us. And it's like, what rules are you talking about? Are you talking about the rules that govern this nation? Are you talking about the rules that govern the state? Are you talking about the rules that govern the town of Telluride? Because I'm pretty sure, like, you got a business owner in there teamed up against, like, there's two lawyers teamed up against one little business owner, and the business owner's trying to like advocate for rights, and these guys are like, we have different rules.
Yeah.
It's crazy.
Yeah, it is crazy. The fact that they're citing a code that just is a blanket terminology of we can, request any information that we see fit. No, that's not a specific code. That's just you citing a code that doesn't have any merit and just like has no validity, really. I don't know. It blows my mind.
Right. But yeah. I'm just like constantly surprised at like how these lawyers responded. They took an oath too, I believe. Like lawyers take an oath to uphold the Constitution. Judges take an oath to uphold the Constitution. And then here we're sitting around in a hearing where it's like, we're going to push you around, we're going to scare you, we're going to intimidate you. We write the rules, and if you got a problem with it, take us to court. Like, yeah, why don't you just delete the words?
Yeah. Yeah, no, and that was done in the nearby municipality. And so Alpine basically, they didn't go silent once they were challenged. They responded in writing again and again, and they even cited case law, Leary versus the United States, which is literally a Supreme Court case about how answering tax forms can violate the Fifth Amendment. And so we can look at the timeline of things and how this broke down. We're looking at right at the beginning of the year, in January 10th, there was a formal objection, and then no response. Fast forward into March 31st, there is a response to noncompliance notice. Moving along still. April 1st and 10th, there's clarification requests to see, like, hey, we're checking in, like, clarification. Nothing. Keep going into April 16th. A legal motion is filed. April 29th and May 7th, Alpine formally follow up on that motion. And what's the result? No reply from the town. Just a show cause hearing scheduled for May 29th. That an Alpine opening statement literally requests, please address our motion before proceeding with this hearing. And there's no response from the town of Telluride. And then May 30th, now Alpine submits formal written final request for the town to address this motion. And the town ignores and retaliates with a new sweeping order demand.
Yeah. As much as it seems like it could be like passive neglect here, it does seem like there's some behind the doors conversations that would suggest that this is a strategy, that like they went into that meeting, the lawyers from the town, and they're like, hey, we can make the rules. We can request any relevant information. Like, that's their strategy. And when you ignore the defense, you control the narrative. Right? It's like, damn, let's be clear. Alpine asked for clarification on what was being asked before the hearing based on the procedures outlined in the Telluride Municipal Code before the hearing date was set, right? So checked all the boxes, This wasn't a favor. They asked the town to follow its own code. The law says you can't punish someone for invoking their constitutional rights. But that's exactly what happened here. And the more we listen, the more we dig into this, the more we see that. And it's like, yeah, like what? So these marijuana businesses, do they have rights or do they not have rights? I know that the federal law sees it one way, but the state law and the local law see it another way. And I believe that the state and the town need to uphold the rights that you get as a U.S. citizen, as a U.S. business. I mean, these guys are profiting and benefiting from the cannabis industry. And it's like, you can't just vacate someone's rights. And so, yeah, after the hearing, what's going on? After the May 29th hearing, did Alpine get a ruling? No, they did not. Did they get a response to their April 16th motion that had 2 different requests before the hearing to acknowledge the motion, and 1 request at the hearing that asked the hearing not proceed until the motion was responded to? And then the day after the hearing, they sent another formal request to rule on the motion. And there's still no answer, right? Instead, on June 4th, the town issues a brand new sweeping order, a new list of demands, right? They've now changed the scope. The hearing happened, all of the rigmarole, and now the town writes back with an order. They want IRS filing. They want federal tax documents. They want sales tax records. They want a full financial audit of the business. They want employee data, payroll, and all due by July 17th. Now, we're really seeing this business get scrutinized as if they've done something wrong, and the town still hasn't clarified. They still haven't formally responded with any meaning to the April motion. And now they come back after this meeting, after Alpine pushes back, the town of Telluride retaliates.
Oh yeah, no, that's not a response. That is a retaliation, honestly. Like, you push back, here's more paper, more risk, more punishment, sweeping order of demands, all due by July 17th. After this hearing that took place, they just want all this information that's outrageous, frankly. It's outrageous. And, in my opinion, this is called administrative escalation. So when they won't answer the issue, they expand it instead and just balloon the demands that they want without actually responding to Alpine's requests for clarification.
Totally. Clearly an intimidation tactic. Clearly a do what we say or we're just going to make this worse. We're just going to do this. We're just going to emit the kind of power that we have. We're going to tell you, like, oh, you can't, this isn't the venue to address that, and your rights don't matter in this venue, and we make the rules. And so what does that result in? The Rule 106 bombshell. When the local process fails. Here's the town of Telluride's legal advice to Alpine during the May 29th hearing. And now the court is actually asked to step in based on that advice. Let's give a listen.
Until a court tells us it's unconstitutional, which no court has, it's lawful. If you think it's unconstitutional, it's not going to stay this proceeding. Well, you're welcome to challenge that in an appropriate venue, which is a court of law, not here.
Okay.
If Mr. Grady wants to challenge the constitutionality of state law, federal law, or the code, it can do so in the proper venue. This is not the proper venue.
Message received. Message received. Okay, clearly, the legal advice that we're getting from the town attorney and, the other attorney that was there was the hearing officer, Mr. Lieberman. Obviously they're not addressing rights. They're not addressing regulations and the process that they're supposed to follow in this hearing. If we want to address that kind of stuff, that's got to go to the proper venue or a court, as stated several times by the town. And so let's take a minute to explain what this rule actually says, because it's a powerful tool and it's very serious. And we're talking about Rule 106A4 of the Colorado Rules of Civil Procedures. And here's the actual language from that. Where any governmental body or officer or any lower judicial body exercising judicial or quasi-judicial functions has exceeded its jurisdiction or abused its discretion, and there is no plain, speedy, and adequate remedy otherwise provided by law, review shall be by the district court. So in plain English, this rule exists for one reason. When the government goes too far and you've got no other way to stop it, boom, you have a right to bring that to court. Either they're outside of their jurisdiction. Telluride clearly is. They're enforcing federal tax policy. And then they're not following their own procedures, you know, and they're like acting like they can just push people around as if they don't have rights. They can push their businesses around and really just like intimidate and retaliate and, you know, show their power or whatever. And Alpine's been stuck in an administrative loop with no due process, no rulings, no responses, just more pressure being applied. And that's what this rule was made for. So a business or a person could challenge a government agency for stepping out of line. This is an important tool that people should know they have so they can stand up to the government.
Definitely. No, it is. It is about, you know, knowing your rights and standing up and exercising that. And so let me try to break this down a little more too. So the term quasi-judicial means that the town was acting like a judge. They're issuing orders. They're deciding consequences for this business just out of thin air, basically. And so they've crossed the line at this point, you know. It started with this application and a checkbox for the federal tax. But now they've ignored a filed motion, issued a show cause order without ruling, and followed up with a new sweep of demands. All those list of demands after the hearing. And that's an abuse of discretion. They've acted without transparency and without limits, you know? Who's holding them accountable? And since the town has really offered no adequate remedy, Alpine filed in San Miguel County District Court under this Rule 106. And, you know, this isn't about money. It's really about forcing the town's actions to face legal review. They should be held accountable, in my opinion. And here's how the town responded to that formal motion and multiple attempts for Alpine's requesting clarification. Let's hear what they said.
Now, why didn't you respond to my motion?
Because I was going to,
On April 6th.
I requested a hearing.
Well, 66104B, Section V, says the authority has the power to hear and decide motions, but you failed to respond to my
Right,
motion.
because we had a hearing set. So we were going to address it now. We asked that it be denied.
All right.
I'm not really sure that that's fair. When I'm asking for clarification on the scope of the hearing and the materials that you're actually requesting. Yeah. Yeah, so the motion was about, hey, what can you it was a clarification and partial dismissal of the hearing because the town came at Alpine saying that they were being dishonest and were non-compliant. And so the partial dismissal of the motion was to remove that language from the public record because they weren't dishonest. They weren't non-compliant. They were actually complying the whole time and responding and, you know, making goodwill attempts to resolve the issue. But the town just ignored the motion and kept ignoring the motion, kept ignoring the requests for clarification that were involved with that motion. Like, what exactly is the code that you're referring to that says we need to give you this information? How do you define federal tax default in the code? Spoiler alert, they don't. The word default isn't defined in the Telluride Municipal Code. There is no requirement for federal compliance in the Telluride Municipal Code. And so Alpine's saying, hey, can you please give me the information about the section of the code that would require me to give you the information? And then please let me know, please let us know what information you're actually looking for. To my understanding, they submitted information showing the administrative process that they're in with the IRS, which involves appeals and offer and compromise and all this stuff going on, because these cannabis businesses are, they're having to deal with the IRS, right? And so to my understanding, the information was submitted. And so the town did not issue more clarification. They didn't respond to the motion. They didn't dismiss the parts of the public record that they kind of falsified. And it's like, wow, like, you guys can just do whatever you want then, huh? Like, you weren't going to take the time to respond to a motion over the course of 6 weeks that was just asking for clarification of what does the Telluride Code say that you're referring to and what information do you want. And so I feel like responding to that motion would have been really helpful to the hearing process before the hearing, because they could have sorted it out outside of a hearing.
Definitely. That's what it sounds like. And it sounds like they just made the executive decision to not respond because there was a hearing scheduled, without giving any sort of response or indication that that was their stance. And then when it's brought up in the hearing, they just dodge it and say, oh, well, because we had a hearing issue, we figured we'd address it then. No, that's not how you go about things.
No, that's exactly why it's in the procedures in Telluride that the person responding to the hearing order can file a motion, and the town has the authority to respond to it and kind of the responsibility. And I feel like in many other instances they would have, but I think because it's cannabis, I feel like there's this like, oh, we don't have to show them any respect. We don't have to show them any rights. Like, and it's like, okay, so you guys are treating us like criminals, actually. Like, what is this? And so now we kind of move on to the next layer, because this is not where Alpine stopped. Alpine filed Rule 106 with San Miguel County Court, but then they also initiated a process, which is serving a CGIA notice, and basically that's a federal civil rights claim, And so Alpine filed that a week or so after Rule 106. And that marks their move to hold the town accountable under federal civil rights law and Colorado's Governmental Immunity Act procedures. And so, kind of neat.
Yeah.
So June 12th, Alpine filed a CGIA notice with the town of Telluride under 42 U.S.C. subsection 1983. That's U.S. Constitution, right? Here's what that means. They're officially calling on the town to answer for this constitutional assault. All right. And under the Colorado Governmental Immunity Act, a written notice is required, usually within 182 days before you can actually sue a government entity for wrongdoing. And so what this means is Alpine has officially started the clock on a civil claim on constitutional wrongdoing. And now the town of Telluride has 182 days to either resolve or go to court with Alpine over whether or not their actions were constitutional, And so really interesting, but this isn't just like a procedural box check. This notice lets Telluride know your unchecked orders, your silence, your aggressive escalation, they've violated our rights. And we're not letting it go. And so officially, clock is ticking. And so that's kind of a huge move.
Oh, yeah.
Like, I don't think we've seen a battle like between a local municipality and a business like this. You usually see, like, a lot of times when cannabis goes to court, it seemingly has a lot to do with the federal government.
Right. Yeah. No, definitely. I think it's exciting. The clock has started, like you said. And so this CGIA's notice requirement, this 182 days to alert the entity that you're suing, is really no joke. It's quite serious. Miss it, and your case could be dismissed before it even begins. So basically, today's like the following, the CGIA's notice is a formal flag, right? Alpine Wellness as an entity is saying, we believe Telluride deprived us of due process, and we're putting you on official notice under subsection 1983. And this section 1983 lets Alpine sue for unconstitutional actions taken under the color of state law. So, like the town of Telluride ignoring filings and coercing responses. Those aren't private disputes. They're constitutional violations. It's pretty serious. So while this CGIA often protects towns from lawsuits, those protections don't apply to constitutional claims under that subsection 1983. So that means that Alpine Wellness is moving from state to federal constitutional terrain, which I think that, not a lot of these businesses, like you said, actually do stand up for themselves. And I think a lot of, local municipalities try to exercise and overexert their power as not only a form of retaliation, but a form of intimidation. And businesses back down and, they go under. A lot of these marijuana businesses do go under. And so this is a big deal that Alpine Wellness is standing up for itself and for the industry, basically.
Yeah. I mean, it's pretty heavy. It's like, wow. I'm like really interested. Right now we're in a 182-day holding period, right? Like this claim was filed. I think the company is waiting to hear back from San Miguel County Court, but the motion has been ordered. And so that's in process under Rule 106. And then, I'm interested to see how the town responds to this. I kind of hope that maybe they say, well, maybe these guys are right. Maybe we didn't have the right to force them to do this. Maybe we didn't have the right to create any relevant rule. It's like you can create any relevant, even if it incriminates somebody, even if it violates somebody's rights under the Constitution, you can, have any in your rule. No, that's not. The final notice isn't just paperwork. It's a challenge. It says you violated our rights and we ain't backing down. And I applaud it. It's like, let's see what happens here,
Oh, yeah. I'm excited. I'm here for it. Up next, we're going to go from town hall to federal court. We're jumping. This isn't just backing down. We're standing up. And because when local government silences you and your business and your rights, sometimes you've got to stand up and escalate it. Oh, baby.
So here's where we are. Alpine filed state law. They operated transparently. They responded to every filing, every letter, every unexplained demand. And for doing all of that, they were ignored, then cornered, then punished. What the town offered wasn't compliance, it was submission. They're still trying to get them to submit. They didn't just want information, they wanted control. They wanted to assert power. And when Alpine refused to lie, refused to incriminate themselves, just to keep their license, the town escalated. They retaliated. It's not about taxes. They want to show their power. And when power refuses to explain itself, that's when you go to court.
Yeah. Oh, yeah. I mean, honestly, there's a difference between regulation and retaliation. And so retaliation says, here are the rules. Regulation, right, has the rules. And, here they are. They're laid out and you follow them. But retaliation says, I don't like how you followed those rules, so I'm changing the game. Yeah. No, what happened after that May 29th hearing was retaliation, plain and simple. There's no ruling, no response to the motion, and just a brand new set of sweeping demands that are absurd, to be honest. And Alpine's final request for a ruling? Ignored. Oh, wouldn't you know it? Ignored.
Right.
And so that's why Alpine filed under Rule 106. Not because they wanted to fight, but because silence had become the town's only language. That was their only response, was a non-response. And so now this question moves from town hall to a courtroom.
Yeah. It's going to be interesting to watch, And I'm stoked. I'm here for it. I wish the Alpine crew the best.
Yeah.
It's going to be a rocky road ahead. They need support. They need attention. They need people to care about this because this whole thing sets a precedent, right? And in more ways than one. It's not just about cannabis. Like, this is about any business, any person being able to assert their rights against a local municipality, a state government, the federal government. We have rights. That's what our nation was founded on, is having rights, being able to protect yourself from the government. And when the government steps out of line, we need to be able to stand up. We need to know what these rules are, what these court filings are, how to file a claim that is based on your constitutional rights being violated. Before this, I got to tell you, I didn't really know, And so let's check out a couple more clips of the hearing, and then we will part ways with you guys. But I think we skipped a couple of the clips on accident, and but I want to see what they sound like here. So let's have a listen.
To address that opening, Your Honor, we're not, if Mr. Grady wants to challenge the constitutionality of state law, federal law, or the code, it can do so in the proper venue. This is not the proper venue. State law makes it clear towns can have an authority. The authority can regulate marijuana as a time, place, and manner. We have a code which does so. We are proceeding under that code, which requires honest, truthful, and full answers to the application. That's all we've been seeking thus far. So we are not prepared, and we don't think it's an appropriate venue to address anything outside of the conditions on the renewal application itself. And from that, Your Honor, really Mr. Lieberman, what we're really looking for is simply compliance.
What does that mean? like we're just looking for compliance.
On a double jeopardy question.
Like, that the company is saying, it's not part of the rules. You guys are making the choice to make this question part of the rules based on the words any and relevant. And what you're demanding is compliance. And it seems like what the business is demanding of the town is compliance.
Right.
With their code.
Right.
Interesting. Let's take a listen to this one.
If we go back to the January 25th renewal order, it said the license has been renewed subject to these conditions. So from the town's position, if we can determine that they are not in default on the federal taxes, then perhaps at that point in time, there'll be no further issue need to be taken on this.
So as long as you're in federal compliance and you are giving us the information, there's no other action that's going to be taken. As long as you do this, there's no other action that's necessary. You can keep your license as long as you conform to the way we've changed the game.
It's ridiculous, honestly. I just think that they're sitting in their high chair and they don't even realize, and that's why legal proceedings are necessary to check. It's check and balances, right? They're just overexerting their power and putting Alpine Wellness in an impossible situation, and then just claiming, we're just looking for compliance.
Mm-hmm. And to my understanding, they've forced Alpine Wellness into this question since 2022. When Lieberman took over. So that Lieberman is the new hearing officer. And when he got in, Alpine they've been in existence since 2010. They've been going through Telluride's hearing process. They've been going through their licensing process for 15 years. There was other hearing officers. There was Jennifer Fox and there was Dan Zemke. Their license was never conditioned on this before, or revocation was never threatened, or any of this stuff. But then this guy comes in 2022 and he's fixated on the federal compliance question. And it seems like he doesn't really know what he's doing, because it's the federal government says it's illegal. So you can't really comply with that in the state, you know? And so, but as of 2022, their answer to this question was they were forced to answer yes. And they were forced to submit documents to the public record. And it worsened the situation, you know, like in a way, like Telluride is helping create the problem here, where it's like you're making them claim that they're actually default, that they actually accept this liability while they're saying we're going through legal proceedings. We're appealing this. We don't agree that we are criminal drug traffickers or that we are liable for the default the IRS has. And you guys shouldn't think that either, because you guys legalized this.
Right.
You guys should be standing behind the industry and supporting the fact that we're not criminals, you know? And so that's really interesting. Now, let's give one more listen here, and then we will wrap it up. But this is the last clip that I have.
As it stands now, the law in the town as the code requires you not to be in default. That was not challenged. That was not appealed, the conditions that were set forth. So that is where the town is at this point in time.
Okay. Yet there's still no language in the code that supports that. The language in the code that they actually bring out in the hearing, that they have, quote unquote, the ground to stand on to ask for it, is that the town can ask for any relevant information. And here we are with this clip at the beginning of the hearing saying the town requires that you can't be. It's like, no, the town doesn't require that. That's why you're interpreting language and you're choosing to apply it here.
Yeah. No,
That's why it's like strategy.
Yeah.
You know?
Oh,
It's like,
definitely.
just follow your own code.
I hear, yeah, it's wild, and honestly, when it comes to Lieberman and his fixation on this federal law, it's really a catch-22 because hey, Telluride, look in the mirror. Have you not been collecting taxes on this business, on this industry? Mm-hmm. Yes, you have.
Yeah, and so has the state. And I feel like what's going to happen here is the state and the town are going to find out what happens when a cannabis company pushes back after they have been benefiting off of the existence of these business owners who are being penalized, and they're ignoring them. They're giving them silence. The state's not intervening to correct the town, right? And that's resulting in Alpine filing formal sales tax protests against the state, which you can do legally. You can send in a formal sales tax protest with a partial remittance and say, we're not paying this sales tax because you guys aren't intervening. You guys aren't supporting us. You guys are ignoring this situation. Our rights are being violated. You're doing nothing about it. You're not protecting us from the federal government. You're not protecting us from the penalties. You're not using all of the tax money that you're collecting that's unpenalized by the IRS to help us with the liability. It's like the business owners are just sitting there holding the bag in the end. And the government's like, well, sorry about you. We're just going to ignore you. And, we'll leave it at there for now because we're going to talk about that probably in the next episode or two. But I feel like that's all the time that we have for today. But, yeah, tune in because the rabbit hole goes deeper.
Oh yeah,
We're going into it here.
Oh yeah, no, it's time to go down the rabbit hole and follow this case and see where things are headed. And it gets dense at some times, but it's super important to stand up for your rights, and as a business to stand up for yourself and the industry and call out when wrongdoings are happening. So I'm all here for it. I'm excited to keep bringing you the latest and the new happenings. We got a great season, some great new episodes coming up. And hey, this is just the beginning.
Mm-hmm. Yeah, you guys got to get out there. Get on our Facebook, please, our Instagram, X. We're on TikTok. Find us, follow us, like us. We're trying to be a good vibe out there in the world, and we're going to need some support. And we want you guys to participate in this. This goes beyond cannabis industry. Like we were saying, this is about rights. This is about how you can advocate for yourself. These are all tools that you can use in any arena. And we're just finding out about it through this industry. And so follow us. Check out our website. check out our YouTube. We're going to launch our online store soon.
Oh yeah.
I got a couple good ideas for a t-shirt.
Oh.
Yeah, I got some like good like little tags. I got some things I'm thinking about. But reach out to us. Find out how you can get in touch. We're trying to raise money through maybe advertising opportunities. If you have money that you can donate to help us keep going, we would love you for it. It's always appreciated. Maybe you have a service or a skill that you want to bring to the table. Maybe you want to find out how you can participate in this case or help Alpine. Hit us up. We are your point contact. You can get us at admin@breakthecipher.com for email, and then find us on social media after that, But we love you guys. We hope to see you soon, and we hope you have a great week.
Oh yeah.
Peace.